Let me be direct with you right now. What happened in that courtroom Thursday didn't just make headlines. It potentially rewrote the rule book on what a sitting president's allies can do with foreign money, how they can hide it, and what happens when the person they trusted most decides to stop protecting them. $340 million, Qatar, a sovereign wealth fund. And Pam Bondi, Trump's own attorney general, sitting under oath, handing prosecutors every single detail. I've spent the last 48 hours going through the transcript, the court filings, the corporate records, and the banking documentation that's now part of the public record. 214 pages of testimony, 4 separate exhibits, 3 financial institutions named directly. This breakdown covers everything the headlines are skipping over. If you want to understand what actually happened, not the spin, not the reaction, not the social media noise, stay with me. Because the Qatar deal specifically is the thread that, when you pull it, unravels everything else. Before we go any further, if this kind of document-level breakdown is useful to you, subscribe right now and turn on notifications. I'm not doing hot takes here. I'm reading primary sources and translating them into plain language. The filings are dropping faster than mainstream media can process them. This channel covers every significant document the same day it hits the public record. Subscribe. Notifications on. You don't want to be catching up on this story 3 days late. Quick context for anyone who needs it. Pam Bondi, former Florida Attorney General, 2 terms. Trump nominated her as U.S. Attorney General in late 2024. Confirmed early 2025. For the better part of a year, she was the institutional face of Trump's legal protection. Every subpoena that came near the White House, Bondi was the buffer. Every congressional inquiry that needed a response, Bondi was the voice. Every time the Southern District of New York started sniffing around financial records that connected to Trump's inner circle, Bondi was the wall. That wall came down Thursday, not because prosecutors broke through it, because Bondi opened the door herself, walked through it, and handed them the blueprint of everything on the other side. Her immunity deal was signed Monday. By Thursday afternoon, she was on the stand in Courtroom 14B, and by 4 p.m. She had provided sworn testimony, physical documents, personal handwritten notes, 47 emails, and wire transfer confirmations totaling amounts that prosecutors had been trying to trace for months. The Qatar deal is the centerpiece of all of it. Let's talk about what the Qatar deal actually is, because the headlines keep reducing it to a dollar figure and moving on. The dollar figure matters. But what matters more is the architecture around it, $340 million. That's the headline number, development project in Qatar. American partners on one side, foreign sovereign wealth fund financing on the other. On the surface, that's a large but not unusual international real estate or infrastructure deal. Foreign sovereign wealth funds invest in American projects regularly. That's legal. That's normal. That happens every week in this country. So what makes this different? 2 things, the structure and the instruction. Let's take the structure first. According to Bondi's testimony on page 147 of the transcript, the Qatar deal was deliberately architected to avoid CFIUS review. For those unfamiliar, CFIUS is the Committee on Foreign Investment in the United States. It's the federal body that examines foreign investment transactions to determine whether they pose a risk to national security. CFIUS has authority to block deals, impose conditions, and require modifications when foreign money entering the U.S. could give a foreign government leverage over American assets, infrastructure, or policy. CFIUS review is triggered by specific thresholds: deal size, sector sensitivity, the nature of the foreign investor, the type of asset being acquired or developed. The regulations around those thresholds are detailed and well known to anyone doing sophisticated cross-border transactions. And according to Bondi's personal notes, which she preserved at her residence and turned over to prosecutors last month, the explicit instruction given in the room was, and these are her documented words, "They know the threshold. Stay under." Read that sentence carefully. This is not accidental structuring. This is not a deal that happened to fall below reporting requirements. This is a deal that was deliberately broken apart, rerouted, or recharacterized. The specific mechanics are still emerging, to intentionally keep it beneath the level that would trigger mandatory government review. That's not complexity. That's not sophisticated finance. That's concealment with intent. And Bondi was in the room when that instruction was given. Now let's talk about the instruction itself, because this is where the Oval Office testimony becomes significant. Thursday, 2:47 p.m. Eastern. Bondi is under direct examination. Prosecutor asks her about a specific meeting. Oval Office, February 14th, 2025. She pauses, looks at her attorney, then answers. Her exact words, pulled directly from the transcript. I was present when the president discussed structuring the Doha Agreement to avoid congressional notification requirements. Two separate oversight mechanisms. CFIUS review, the national security screen, and congressional notification, the legislative oversight requirement. The Qatar deal, according to Bondi's sworn testimony, was structured to avoid both. This is not alleged. This is not leaked. This is testimony under oath from a cabinet-level official who was physically present in the room when the conversation took place. Trump's defense attorney requested a sidebar immediately. Prosecutors called a 15-minute recess. 3 reporters walked out of the courtroom to file within minutes of that testimony being delivered. When proceedings resumed, Bondi continued. She described the deal in detail, the American partners involved, the routing of the foreign financing, the timeline of the structuring decisions. And critically, who else was in the room? 8 people total, current and former officials, and 1 sitting member of Congress. Within an hour, portions of the transcript were sealed. But not before reporters had captured the essential substance of what was said. Let's go deeper on why the Qatar connection specifically matters beyond the legal exposure. Qatar isn't a random foreign investor. Qatar's sovereign wealth fund, the Qatar Investment Authority, is one of the largest and most strategically active state-owned investment vehicles in the world. It holds significant positions across global real estate, infrastructure, financial institutions, and defense-adjacent sectors. Qatar also has a complicated relationship with U.S. foreign policy. It hosts the largest U.S. military base in the Middle East, Al Udeid Air Base. It has simultaneously maintained relationships with actors that U.S. policy designates as problematic. It played a central role in negotiations involving hostage situations and regional conflicts. It is, in short, a country where a $340 million investment deal structured to avoid national security review is not a routine matter. When CFIUS exists, it exists precisely for situations like this. A foreign government with complex geopolitical positioning investing hundreds of millions of dollars into a U.S. project in a structure deliberately designed to avoid the review process that exists to assess exactly that kind of risk. And according to the testimony, people in the Oval Office knew the thresholds, knew the review would be triggered at a certain level, and gave explicit instructions to stay beneath it. Now let's go to the paper trail, because this is where Bondi's testimony shifts from credible to potentially overwhelming for the defense. Page 34 of the court filing, first document submitted Friday. The language is precise. The witness confirmed direct knowledge of 3 separate agreements executed between January 2025 and August 2025, each involving payments routed through intermediary entities. 3 agreements, 8 months, intermediary entities, page 89, paragraph 47. Bondi testified that she personally reviewed wire transfer confirmations totaling $18.2 million sent to a Nevada holding company. No employees, no office, no visible business operations whatsoever. I pulled the Nevada corporate records. That company was registered 6 days before the first wire transfer arrived. It was dissolved 11 days after the final payment cleared. A company that existed for the precise duration required to receive and presumably reroute a specific sum of money, then ceased to exist. That's not a business. That's a mechanism. Page 112, Exhibit F. Bondi provided 47 emails between herself and 3 members of Trump's inner circle, sent during a 2-week window last spring. Subject lines documented in the transcript include, these are direct quotes, repayment arrangement and offshore structure urgent. Those emails were sent while Bondi was serving as U.S. Attorney General, and she handed all 47 of them to prosecutors. Here's what the combined picture looks like when you lay it out. A $340 million development deal connected to Qatar's sovereign wealth fund, structured below CFIUS thresholds intentionally per documented instructions given in the Oval Office. Payments routed through Delaware LLCs with minimal documentation. An intermediary Nevada company that existed for 17 days received $18.2 million and disappeared. Wire transfer confirmations personally reviewed by the sitting Attorney General. Emails about offshore structures and repayment arrangements sent on government time by a cabinet official. Personal notes kept off-site, preserved against explicit instructions not to document certain conversations. And the person holding all of that documentation is now a cooperating witness with an immunity deal signed 4 days before she took the stand. The defense will argue, and they already have, that Bondi had every incentive to produce damaging material because her own immunity depended on delivering value to prosecutors. That's a legitimate argument. Witnesses with immunity deals are inherently compromised in terms of pure credibility. But here's what makes this different from a typical cooperating witness situation. Bondi didn't just testify. She brought the paper. The emails are independently verifiable. The wire transfer confirmations are independently verifiable. The Nevada corporate records are public documents. The banking records are being independently subpoenaed from 4 international financial institutions as we speak, including one in the Cayman Islands. Prosecutors don't subpoena 4 foreign banks within 72 hours of testimony if the testimony is the only evidence they have. They do it because the testimony told them exactly where to look, and they're now verifying what they already believe they'll find. You can attack Bondi's credibility. You cannot attack a wire transfer timestamp. The response from Trump's team has been aggressive and, frankly, strategically counterproductive. Thursday night, 11 Truth Social posts in 3 hours. Bondi described as mentally unstable, desperate, a disgrace. The first post stated she was never smart enough to understand what she witnessed and called her a confused woman. That post received 4.7 million views in 12 hours. Bondi's attorney requested additional security measures Friday morning. Saturday morning, Trump's legal team released a formal statement describing Bondi's testimony as the product of prosecutorial coercion and personal desperation. Saturday afternoon, they filed a motion to exclude portions of the testimony, citing attorney-client privilege on several of the conversations Bondi described. Prosecutors responded the same day. Bondi was not functioning as Trump's attorney during those conversations. She was a witness to them. The privileged claim doesn't apply to third-party observers of conversations, regardless of their professional title. That dispute gets resolved Tuesday. But here's the pattern worth noting. Every social media post attacking Bondi gets cited in prosecutorial filings as potential evidence of witness intimidation. Every aggressive public statement becomes part of the record. Trump's team is generating documentation of their own reaction in real time, and prosecutors are collecting it. The strategy of publicly attacking a cooperating witness while simultaneously filing legal motions to suppress her testimony is not coherent. You either argue she's unreliable, in which case you don't need to suppress her, or you try to suppress her because she's credible enough to be dangerous. Both at once signals panic. The broader fallout from Thursday is still developing. 3 additional subpoenas were issued Friday afternoon. 2 former White House staffers. 1 current member of Trump's legal team, the Nevada LLC, is now under active federal investigation. 4 international financial institutions have been ordered to produce banking records on an expedited timeline. One of those institutions is based in the Cayman Islands, one of the 3 foreign jurisdictions alongside Qatar and Cyprus, referenced in the unsealed portions of Bondi's testimony. A sitting congressman was named under oath. That individual's office has declined all press inquiries and redirected everything to legal counsel. A second person referenced in the testimony publicly retained a white-collar defense firm in Washington, D.C., and issued an unprompted statement denying wrongdoing. Nobody had asked him to comment. The judge, Judge Mercer, scheduled an emergency status conference for Tuesday, March 10th. The docket entries show expedited discovery was requested Friday afternoon and granted within hours. The acceleration of the timeline wasn't reactive to media pressure. It was a calculated judicial response to the specific content of what was testified. Something in that 214-page transcript pushed the court to move faster than scheduled. Let's talk about what's still sealed, because this might be the most consequential unknown in the entire story right now. Bondi testified for 4 hours. 90 minutes of that testimony is part of the public record. The remaining 2.5 hours were sealed at the prosecution's request, pending further investigation. 2.5 hours of testimony from a cabinet-level cooperating witness about a $340 million foreign deal structured to evade oversight, and we have access to less than half of it. The sealed portion was protected at prosecution's request. That's significant. Defense attorneys typically push for sealing when testimony is damaging to their client. Prosecution requests sealing when disclosure could compromise ongoing investigations, expose witnesses not yet protected, or reveal the scope of what's coming next before prosecutors are ready to move. The fact that prosecutors sealed it themselves tells you something about what's in there. They're not protecting Trump. They're protecting their own strategy. Legal analysts with Estini experience have been consistent on this point. When the prosecution seals their own witnesses' testimony, they're either protecting other cooperators who haven't come forward yet, or they're setting up for something larger and don't want to tip the timing. Both possibilities should make Trump's legal team very uncomfortable. Constitutional law scholars have been weighing in since Friday, and the framing is important. The attorney-client privilege dispute isn't just a procedural fight over what portions of Bondi's testimony can be used. It's a direct test of how far executive privilege and professional privilege extend when a cabinet official observes, rather than participates in potentially criminal planning. If the privilege motion fails, and most analysts believe it will, because Bondi was a witness to conversations rather than a legal participant in them, then the full scope of her testimony becomes accessible. That means the remaining 2.5 hours of sealed transcript potentially become part of the public record. If it succeeds, Trump's team buys time. But the underlying documentation, the emails, the wire transfers, the corporate records, the banking subpoenas, none of that is touched by privilege arguments. The paper exists independent of testimony. A former federal judge now teaching at Georgetown Law put it plainly on Friday. Attacking the witness doesn't neutralize the documents. The documents are self-authenticating at this point. They either say what they say or they don't. And based on what's already in the public record, they say quite a lot. Here's what I want to zoom out to for a moment, because I think the scale of this gets lost in the daily filing-by-filing coverage. Pam Bondi was not a fringe figure who occasionally had access to sensitive information. She was the chief law enforcement officer of the United States. She sat in cabinet meetings. She received classified briefings. She had access to conversations, deliberations, and decision-making processes at the highest levels of government. Not as a visitor, not as a consultant, but as a principal. When a person at that level cooperates with federal prosecutors and brings contemporaneous physical documentation, notes written in real time, emails sent and received on government infrastructure, wire transfer confirmations personally reviewed, the evidentiary weight is categorically different from a typical cooperating witness situation. This is why former Estini prosecutors keep using the word earthquake. Not because the allegations are more serious than other cases, though they are serious, but because the source, the access level, and the documentation are a combination that defense attorneys genuinely have no clean answer to. You can discredit a witness, you can challenge memory, motivation, interpretation. But when the witness arrives with her own contemporaneous record of what she observed, created at the time, preserved independently, and corroborated by external banking and corporate records, the credibility attack has limits. The practical implications extend beyond the courtroom and beyond politics. Friday afternoon, defense contractor stocks fell 2.3% following the Qatar connection becoming public. Investors with exposure to companies operating in politically sensitive sectors, particularly those with foreign partnership arrangements or government contract dependencies, are now in active compliance review mode. Federal employees and agencies connected to the individuals referenced in Bondi's unsealed testimony began receiving legal hold notices. Preserve all documents. Suspend routine deletion protocols. Effective Monday. The markets are pricing in uncertainty. The federal bureaucracy is preparing for expanded investigation scope. The legal community is watching Tuesday's privilege hearing as a leading indicator of how quickly this escalates. Here's the timeline of what comes next. Tuesday, March 10th, status conference. Judge Mercer hears arguments on the privilege motion. If it fails, expect significant additional portions of Bondi's testimony to become public within days. If it succeeds, expect an immediate prosecution appeal. Thursday, March 12th, the grand jury reconvenes. New evidence presentation is expected. Sources familiar with the proceedings have indicated prosecutors may present banking records from at least 2 of the 4 subpoenaed international institutions, assuming the expedited timeline holds. March 17th, tentative. Next witness testimony. Identity not yet disclosed publicly. The fact that prosecutors already have a next witness scheduled and sealed that identity suggests Bondi is not the end of the cooperation chain. She may be the beginning of it. So where does this leave us? Pam Bondi walked into courtroom 14B Thursday morning as the most recognizable face of Trump's institutional protection. She walked out as a cooperating federal witness who had just handed prosecutors a $340 million foreign deal, 47 emails written from inside the Justice Department, wire transfer records for a shell company that existed for 17 days, personal notes documenting an explicit instruction to evade national security review, and the names of 8 people, including a sitting U.S. congressmen who were in the room when the critical decisions were made. The defense has arguments. Immunity-tainted testimony, cooperative witnesses under pressure, the complexity of international finance, the legal legitimacy of LLCs. These arguments are real. They'll be made. Some of them will land, but the paper exists. The transfers happened. The company was registered and dissolved on a timeline that matches the payments with surgical precision. The emails were sent on government infrastructure by a cabinet official who was simultaneously supposed to be the country's top law enforcement officer. And the sealed 2.5 hours of testimony that we haven't seen yet, prosecutors sealed it themselves. That fact alone tells you something about what's coming. Tuesday is the next inflection point. The privilege motion ruling sets the tempo for everything that follows. If the sealed testimony opens, the story accelerates faster than most people are currently tracking. I'll be covering the Tuesday hearing in detail. When the transcript releases, if it releases, I'll break it down the same day. Same level of depth. Same document-by-document approach. No hot takes, no spin, just the primary sources translated into plain language. Subscribe if you want to stay ahead of this. Notifications on. This is moving fast, and the gap between people who are following the actual filings and people who are following the headlines is growing every day. The machinery is in motion. Bondi opened a door on Thursday. What comes through it by the end of next week could define the rest of this story. I'll be here. Talk soon.